Lordship will see that there is a condition precedent in Article 3. And this condition precedent, my Lord, was added to by CO 48, which I'll show to your Lordships in a moment, my Lord. Which further required the bill to be sent to the legislature of the state, but we're not concerned with that because it has to be sent to every single state. Now, my Lord, I take your Lordships to this notification, C subclause 2. So much of the first proviso of Article 3 of the Constitution as relates to the reference by the President to the legislature of the state, and the second proviso to that article, so that much of Clause 2 of 151, which is about audits, my Lord, of the Constitution as relates to laying before the legislature of the state of the report submitted by the Governor to the Controller Auditor General. You will see that the opening sentence is, the following provisions are suspended. In other words, my Lord, a mandatory provision of Article 3, whether it applies to Kashmir or elsewhere, my Lord, is suspended. It's not a question of just laying before Parliament as a substitute. Article 3 and Article 370 does not tolerate substitutes. Now, my Lord, what does this do? This is not, my Lord, that can be done under a proclamation under 356. It is a constitutional amendment which is subversive of the Constitution itself. If this suspension fails, my Lord, President's rule will fail. And its extension, my Lord, in July will also fail. You have amended the Constitution, albeit to all states and certainly to Jammu and Kashmir. And this mandatory provision takes us to the core of the mandatory requirements, my Lord, of Article 3. Because the entire J&K or Reorganization Act emanates from Article 3 and Article 4. Take away this condition, my Lord.
How do we deal with this Article 356(1)(c)?
Sorry, my Lord.
Article 356(1)(c) says that if he may make a proclamation where a situation has arisen that the government cannot be carried on in accordance with the provisions of this Constitution in any state, and then C.
Make such incidental and consequential provisions as appear to the President to be necessary or desirable for giving effect to the objects of the proclamation, including provisions for suspending in whole or in part the operation of any provision of this Constitution relating to any body or authority.
So the President has a power to suspend certain provisions of the Constitution during the operation of a proclamation under 356.
The suspension in this case goes beyond supplement, my Lord. It goes to actually taking out a mandatory provision. Of course, my Lord, Article 4 says that any change that is made will be treated as not requiring an amendment. But leave that aside, my Lord. How is 3 and 4 to operate after this? The presidential duty, my Lord, has to be a little more careful. Because this was tailored way back in 19th December 2018 to start a process, my lord, of amending the constitution for the purposes of which
Normally when the legislature, here of course it's the constitution, uses the expression means and includes. Here it's not means, but it says make and includes. When means and includes is used by the legislature, it's an indication of expanding the power. So when the constitution says, it begins by saying make incidental or supplementary provisions,
Yes.
and then says including. So this including seems to be to widen the ambit of what was stated earlier. Namely, the earlier part says you will make incidental or supplemental provisions. But then it says including. So including would mean that what was otherwise not a supplemental or incidental provision is within the ambit of the presidential proclamation, isn't it? Because suppose the clause C read just up to proclamation and didn't have and including. It's not and including, it's including.
That's right.
Suppose it ended
Suspending
with the
in
word
whole or in
proclamation.
part the operation of any provisions of the
So
constitution.
if the last part of Article 356(1)(c) was not there, you could have challenged any amendment of the Constitution on the ground that you don't have the power to make an amendment of the Constitution in the guise of making an incidental or supplemental provision.
Lord, this is the basis of our challenge, my lord. In our petition, we have challenged only the suspension.
My question is this: suppose the President in a proclamation suspends the operation of any provision of the Constitution. Is that amenable to a challenge on the ground that it is not incidental or supplemental? Or are these words of widening the ambit of the first part of 356(1)(b) so as to be immune from such a challenge?
This, my lord, has remained within the limits of 356. That is, for the governor, you read the president. For the legislature, you read the legislature. But I've never seen a provision in any proclamation, my lord, throughout, my lord, these decades, which actually uses the supplemental and including. I've never seen it take away a mandatory provision of the Constitution. This is exceptional, my lord. Now you can read it together in one way, you can read it together in the other way. If you expand 356(c), my lord, then you will say that the president has a carte blanche to amend any part of the Constitution as part of the supplementary provisions.
Can you, for example, say that there'll be no judiciary in the state?
That's right, my lord.
That's what you're
That may be covered by the proviso, but at any
right.
rate.
Oh yes, the proviso
So,
says, of
Lord,
course.
supplementally, this 356(c) has to be read with the mandatory provisions which it cannot dilute.